AR gravity, any day above ground, live it. Hope everyone's doing well on this Tuesday. Good morning, good morning, good morning. Damn, it's cold out here, boy. But like this post says, we're going to bring the heat. Programming note, I just put it on X as well. Tomorrow, I will be covering that Mahogany Jackson story. I don't want to because I actually watched the court case, like the clips of what happened in the court yesterday, and I'm disgusted. But I'm going to make sure I cover that tomorrow before I go to the plantation. That's not what we're here for. We're here to talk about this. Now, a lot of people don't know that this happened, but this is why I say you got to pay attention to things that go on out here because everything is interconnected, even though you may think it's not. Now, I know last week I talked about TikTok and how this could be an infringement on the First Amendment because they're trying to ban that app. But a lot of people don't know that Biden is being sued right now for trying to infringe on the First Amendment. Damn it, I said his name.
Insult to my existence.
Yeah. So her name was Kayla. I forgot her last name. I apologize. But they went down to talk to the Supreme Court yesterday in regards to a case called NRA v. Volvo. Why am I saying Volvo? Vullo. And it's basically a case that they're saying that the Biden administration overstepped their bounds by censoring posts on social media. And I guess we can just begin here. Old Kuntanji, which we told y'all is very dangerous out here. She went and said something that I don't think she should have said this. She shouldn't have said this. But we're going to show you what she said before we listen to these oral arguments. Ooh.
You know, let me go here. There's a growing concern.
Now, this is in regards to another case, but considering that she said this and then she's going to potentially rule on for free speech, it's kind of alarming. But again, we warned y'all that they only picked her so they could continue their white supremacist agenda. But y'all didn't want to listen because it's sister girl. But that's not what this is about. So it says Ketanji Brown Jackson comments raise MAGA's eyebrows. Supreme Court Justice Ketanji Brown Jackson's comments on Monday regarding the First Amendment amid the Murphy v. Missouri case as Donald Trump's Make America Great Again supporters raised concerns. On Monday, the Supreme Court heard arguments in the case brought by two Republican attorney generals from Louisiana and Missouri, as well as 5 social media users who accused the Biden administration of going too far and putting pressure on social media platforms to take down misinformation. The plaintiffs argued the moderation of content amounted to censorship that violated their First Amendment rights. But justices across the ideological spectrum appeared highly skeptical about the claims that the Biden administration crossed the line and coerced private companies into removing problematic content. The court's decision in this and other social media cases is expected to make an impact as it could set standards for free speech in the digital age. During Monday's arguments, Jackson was one of the justices who seemed skeptical of a ruling that would broadly restrict the government's communications with social media platforms as she raised concerns about hamstringing officials' ability to communicate with platforms about certain matters, specifically posting towards the C-19 pandemic. So basically, you have two cases that are about the First Amendment. Now, this case that I'm talking about is about the NRA saying that New York law is prohibiting them from doing business. That's a freedom of expression, freedom of doing business. But what we're going to discuss today in regards to that, as well as this case, this Murphy v. Missouri, this is why I tell y'all we got to vote Congress out. We definitely got to vote them out. And yes, I will acknowledge those who are in the room in a minute. We got to vote them out. They're not doing anything for us. All they're doing is collecting lobbyist money from their corporations and doing nothing for the people. Y'all could worry about Trump and Biden all you want. I could care less. I'm worried about Congress. But let's see who's in the building. Sorry if I sound a little lethargic. I've been up all morning reading on both these cases. Wake up, goddammit. That was me slapping myself. Okay, let's see. Torian Rain Reloaded, good morning. Reparations Nation, good morning. Yohan Sellers, good morning. Miss Nisi, good morning. Black Women Stand Up, good morning. For those who haven't said anything in the chat or the live chat or the comments, good morning. All right. Let's get into this. Now, the justices said something, and he was talking yesterday. Whew. This is a crazy time to be alive. Crazy time to be alive. We might have to figure out where we're going to start talking. You might have to start talking. They had a whole bunch of the disinformation dozen down there, either trending or talking. But let's get to the good stuff.
You know, let me go here. There's a growing concern.
All right, so these are the oral arguments. There's no video except this. But let's start. We're only going to highlight what the justices have said. We're not going to highlight other people. I just want y'all to get an understanding of how they think. So, fair use.
That problem inherent in it. But the Fifth Circuit injunction is what's before us, correct?
Correct.
And it says to encourage or significantly to coerce. That's a legal term.
Yep.
Or significantly encourage, and you're questioning what the meaning of significant encouragement is. And I'm not sure I know exactly what the Fifth Circuit meant, but we can figure that out. Let's just use to coerce social media companies to remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected speech. How is that harming the government? I want some specifics.
I'm happy to do that. And I'll say first, just to be clear, because this court has stayed the injunction, fortunately, it's not harming the government now. But there were times when we were getting exactly right. So I think the problem with that, we don't say that the government can coerce private speakers. That is prohibited by the First Amendment. But the problem with the Fifth Circuit's injunction saying don't coerce or significantly encourage is that it comes at the end of 80 pages of legal analysis, holding that the government had done those things by, for example, when the FBI would send communications to the platforms saying, for your information, it has come to our attention that the following URLs or email addresses or other selectors are being used by malign foreign actors like Russian intelligence operatives to spread this information on your platforms. Do with it what you will. That, the Fifth Circuit held, is coercive because the FBI is a powerful law enforcement agency. And I think if the injunction were put in place, the FBI would have to think very hard about whether it could continue to do that. Similarly, I think both the Fifth Circuit and my friends have really said that the crux of what they claim was coercion here was what happened in July of 2021 when the Surgeon General, the White House press secretary, and the president himself made statements criticizing the platform's practices on misinformation and false statements about COVID vaccines and calling on them to do better. I think it's really troubling, the idea that those sorts of classic bully pulpit exhortations, public statements urging actors to behave in different ways might be deemed to violate the First Amendment. And I think if the injunction were to go into effect and the president or his senior advisors, the president isn't enjoined, but if his senior advisors, the press secretary or someone else, wanted to talk to the public about other problems like the circulation of anti-Semitic or Islamophobic content on social media platforms, or the effects they might be having on children's mental health, or national security issues like the anti-Semitic Osama bin Laden letter that was trending on TikTok at the end of last year that we referenced towards the end of our brief. I think all of those things could be done only under the shadow of the injunction. And that comes around to the other point that you made, which is that this injunction, especially read in light of the opinion that comes before it, is extremely vague. And I think having that sort of vague injunction with these contestable legal terms that have been interpreted very broadly as applied to past conduct, hanging over the heads of all of these government officials doing all of these things, is a real problem. And I think especially so when you're talking about entering such an injunction at the behest of 2 states and 5 individual social media users whose main complaints are about the moderation of posts about COVID-19 many years ago that they haven't really even shown were traceable to the government to begin with, we think. And we certainly don't think that they've shown that they face the sort of imminent threat of future injury that's required to satisfy Article 3.
Mr. Fletcher, let me follow up on that. If even one of the plaintiffs has standing, then we're required to get to the merits. So let me ask you about Ms. Hines. And as you just mentioned, she must have faced an imminent threat of future injury at the time when the complaint was filed, and that injury must be traceable to the actions of the government. So in the first part of that, imminent threat of future injury, her Facebook personal account was restricted at the time when the complaint was filed. So why isn't that sufficient to show an imminent threat of future injury?
We're not disputing that when the private platforms moderated the plaintiff's pages or their posts, that's an injury in some sense. We haven't disputed that they suffered that injury. We've disputed the traceability question and then the redressability question.
Right. So on traceability is basically a question of causation, right?
Agreed.
All right. Both the district court found that the injury was traceable to the government's actions, and the Fifth Circuit accepted that finding, reviewed it, and accepted it. So that's 2 lower courts. We don't usually reverse findings of fact that have been endorsed by 2 lower courts, and you haven't attempted to show that it was clear that that finding is clearly erroneous.
So respectfully, Justice Alito, I disagree with that. I think that the Fifth Circuit and the district court applied too loose a notion of traceability. They didn't try to say this post or any action against Ms. Hines was traceable to any action by the government. They did what the red brief calls a bird's eye view of traceability. They said the government is talking to the platforms a lot. The platforms are doing moderation. And so we'll just assume that all of that moderation is traceable to the government.
Well, do you think that...
Did you hear that? I need y'all to listen to that part again.
Too loose a notion of traceability. They didn't try to say this post or any action against Ms. Hines was traceable to any action by the government. They did what the red brief calls a bird's eye view of traceability. They said the government is talking to the platforms a lot. The platforms are doing moderation. And so we'll just assume that all of that moderation is traceable to the government.
Well, do you think...
It's very important. I need y'all to bookmark that in your minds. He's basically saying that the big tech has been given carte blanche to do whatever they want, and the government is basically over their shoulder just watching, but assuming that they're doing the right thing. The only time you see the government intervene is when something they know is true is getting traction and they didn't approve of it to be out there, i.e. the laptop, i.e. the truth on the Belle Biv DeVoe.
That it's necessary to identify a single government action and then trace it to a single consequence. Do you think that's required?
No, but I think you have to trace some government action to some consequence that befell you. And maybe I could just be specific about this because we challenged this in our opening brief, and the red brief comes back at pages 19 to 21 and offers up what I take to be their best examples of traceable harm. And I invite you to go look at the pages of the record that they're citing, because often what you find is that they're citing moderation of their content that happened either before the challenged government actions to which they're referring or long after.
All right, I have looked at that. On the issue of causation, under Mount Healthy, are they required to show anything more than the government's action was a motivating factor?
I don't know the answer to that in all cases, and I'm reluctant to make sort of broad statements about what the traceability requirement demands in different circumstances. I will say here, we're not disputing that. We're saying that they haven't shown any causal connection between the...
Has no effect whatsoever.
Right. And the reason...
Both the lower courts were wrong on that.
I think they were, because again, they did this blunderbuss approach where they said the government is talking to platforms about moderation and the platforms are moderating content, but the platforms were moderating this content long before the government was talking to them. They had powerful business incentives to do the same thing. The acts of moderation were consistent with the platform's own policies. And this is, I think, another telling fact. In those red brief examples that we talked about on pages 19 to 21, some of them involved platforms like LinkedIn that wasn't even the subject of the challenged White House and Surgeon General's office communications with the platforms.
Do you think that there are any factual findings with respect to standing that we are required to give clear error review to?
I think findings of historical fact, absolutely. We're not fighting that. So the idea that pieces of content were moderated, that the government made certain statements, and if there had been findings that said Facebook deleted this post because of these communications by the government, that would be a factual finding of historical fact, but there just aren't such findings.
Right. I mean, that's what I was really getting at. Are there findings that you concede, that one you have to apply clear error review to, that one you have to do the same?
Yeah, we do. And I can't give you a list because there's a lot of facts in this case, but we agree historical factual findings count. What we say don't count are findings that are really characterizations, which is a lot of what my friends are relying on, findings that are about the application of law to facts, which in this constitutional realm we think get de novo review, and then findings that are premised on erroneous legal standards.
So Mr. Fletcher, I just want to nail down what your views are on the legal standards. On traceability, you're not disputing that a motivating factor is enough.
We haven't made that argument here. That's right.
Okay. And then on redressability, what's your view of the legal standard the court should be applying?
I think, again, it has to be some showing that I think likely to redress the injury is the standard from Lujan. So it doesn't have to be certain, but you have to make some showing that an injunction against the government will stop the platforms from doing
in Massachusetts versus EPA, we've said likely to some extent. Does that strike you as correct?
I think in the context of Mass versus EPA, maybe where you're talking about a problem of degrees, here where the concern is, are the platforms going to moderate my posts or not? And are they going to do it because of the government or not? And will an injunction against the government to stop Facebook? And
to some degree, is that an acceptable standard to the government?
I guess
I just want to know what my yardstick that I'm supposed to measure these allegations against. And there's not a lot in your brief about it. So I take likely from Lujan.
Yeah.
I take to some extent from Massachusetts versus EPA. And I take the statement in Larson that it doesn't have to address every injury.
Agreed.
You agreed with all of that?
Except that to some extent, I think the state's injury was about rising sea levels. And so to some extent means it doesn't have to solve the problem. It has to help it.
All right. I'm going to go a little bit forward because we got to listen to what this plant said. Strap in.
Coercion, then we automatically have government and a First Amendment violation. I mean, I appreciate the coercion point, and that's sort of the government's first point with respect to the merits of this. But I'm interested in your view that the context doesn't, quote, change the First Amendment principles. I mean, I understood our First Amendment jurisprudence to require heightened scrutiny of government restrictions of speech, but not necessarily a total prohibition when you're talking about a compelling interest of the government to ensure, for example, that the public has accurate information in the context of a once-in-a-lifetime pandemic. So I'm just interested in the government sort of conceding that if there was coercion, then we automatically have a First Amendment violation.
So I'm not conceding that that would be the case. I could imagine that in times of pandemic, if there were actual restrictions, maybe those would be justified. But our position here, because we think it's the position consistent with the facts, is that there wasn't any coercion to begin with.
Mr. Fletcher, on that point, you mentioned coercion repeatedly in terms of threats. Can there also be coercion in your view in terms of inducements?
We think there can. I think often a threat or an inducement is sort of the flip side, one or the other. I think in the next case, you could construe it either way, threat of prosecution, offer of leniency. So we acknowledge that it could be both, but it has to be a threat or an inducement of some concrete government action, not just of more government speech.
And hypothetically, and I'm not saying this happened here, but would a threat or an inducement with respect to any trust actions qualify as coercion?
Sure.
And a threat or an inducement with respect to Section 230 qualify?
So I think that one's harder for two reasons. One is that these are executive branch officials who don't have the ability to unilaterally enact 230 reform. I think the question is...
They have a power to influence that.
But the question is...
Would that be enough to say we're going to, if you don't do X, we are going to change our position on Section 230?
So potentially yes as to legislation. 230, if I could just get this out though, I think is different because 230 is about content moderation. It's about this very issue. And I think a government official has to be able to say, I support Section 230 reform because I'm concerned about these things. And also in the meantime, I think platforms should be doing better.
I understand that. But in terms of advocating for change of Section 230, that could be coercion in your view.
If it were framed as a threat, our position wasn't done.
And how about saying you're killing people? Could that be coercion in some circumstances? That if you don't change your moderation policies, you're responsible for killing people.
So I think that one is much harder. That's a statement that President Biden made off the cuff.
Listen, I'm not talking about the context specific issues, and I understand you have arguments there, but could that in some circumstances, an accusation by a government official that unless you change your policies, you're responsible for killing people, could that be coercion?
So I find it hard to imagine a situation where that sort of public statement could be. I'll acknowledge, as you say, context matters a ton, and so I don't want to say it's impossible. All I'm saying is it didn't happen here. The president said this to the public in the middle of a pandemic, and then 3 days later, I think this is important, he clarified. He said, I'm not saying Facebook is killing people. I'm saying the people spreading misinformation are. And when he was asked, will you hold the platforms accountable? He was explicitly asked this, will you hold them accountable if they don't do better? He said, I'm not looking to hold anyone accountable. I just want everyone to look in their mirror and imagine what would happen if this misinformation was going to their loved ones. I think it's clear that this was exhortation, not threat.
Thank you, Mr. Fletcher. How are we supposed to evaluate that question and what the level at which coercion kicks in? I mean, if you're trying to coerce or get a particular result out of a media outlet, is it enough to say, you know, if you don't do this, we're going to move your reporter's cubicle down the hall? Or how do you evaluate when it constitutes coercion in this context?
So let me start with, I think Bantam Books has been the lodestar for the lower courts that have mostly coalesced with some errors in application like this case around the idea of the question is it a threat or a statement that a reasonable person would understand, viewed objectively and in context, as an implicit or explicit threat of some adverse government action? Now, as to the cubicles question, I sort of don't know if there are some adverse government actions that are so trivial that they don't count. I guess I think something like that seems less likely to be a coercive threat. But in general, I think our position is if there's something that the government is saying that we're going to exercise government power in some way, unless you change your speech in some way or stop distributing the speech of others, if it's reasonably understood as that sort of a threat, that's a First Amendment problem.
Well, but under Bantam Books, it presumably is in context what you're talking about a reasonable person. I mean, if there is, as a regular basis, the kind of back and forth between a spokesman and a member of the media, what a reasonable person might view as coercive might not in that context. You know, maybe the press secretary yells on a regular basis, and if their volume increases enough, that might be viewed as coercion.
So I think that points out the context sensitivity. I think, as is usually the case when the court says it's a reasonable person test, it's a reasonable person with knowledge of all the facts. And I think that would include the prior course of dealing between the relevant government official and the relevant recipient. I think here that really strongly reinforces the idea that there wasn't coercion. These were sophisticated parties. They routinely said no to the government. They were open about it. They didn't hesitate to do it. And when they said no to the government never engaged in any sort of retaliation. Instead, it engaged in more speech. Ultimately, the president and the press secretary and the surgeon general took to the bully pulpit. We just don't think that's coercive.
Thank you. Justice Thomas?
Mr. Fletcher, back to my point about coercion. Couldn't you simply censor someone or prevent other speech by others by agreeing with the platforms as opposed to coercing the platforms?
I guess I'm not sure what you mean by agreeing.
Well, you just work together, said, look, we're right, they're wrong. Let's work together. You know, we're on the same team. Let's work together to make sure that this misinformation doesn't gain sort of any following.
So I think as long as the platforms are exercising their own independent judgment, that's what the First Amendment protects. It says we don't want the government messing.
So you're saying that the government can't censor by coordinating with private parties to exclude other speech?
I'm saying that when the government persuades a private party not to distribute or promote someone else's speech, that's not censorship. That's persuading a private party to do something that they're lawfully entitled to do. And there are lots of contexts where government officials can persuade private parties to do things that the officials couldn't do directly. So, for example, recently after the October 7th attacks in Israel, a number of public officials called on colleges and universities to do more about anti-Semitic hate speech on campus. I'm not sure, and I doubt that the government could mandate those sorts of changes in enforcement or policy, but public officials can call for those changes. The government can encourage parents to monitor their children's cell phone usage or internet companies to watch out for child pornography on their platforms, even if the Fourth Amendment would prevent the government from doing that directly. All of those are contexts where the government can persuade a private party to do something that the private party is lawfully entitled to do. And we think that's what the government is doing when it's saying to these platforms, your platforms and your algorithms and the way that you're presenting information is causing harm, and we think you should stop. And the platforms are.
So you really don't see any difference between the government coordinating with the platforms to exclude other speech and persuading the platforms to do this, to not engage or permit other speech?
I guess I'm not seeing it, and I think that what happened here was definitely on the, if you do think there's a difference between those two things, I guess my argument here would be that what happened is on the persuasion side of the line, because you do see that back and forth of the platforms throughout the process saying no repeatedly when they disagree with what the government is asking them to do. And I think that tells you that what was happening here is what the First Amendment protects, which is private speakers making independent judgment, informed by, maybe even influenced by the government.
So there's no difference between the platforms meeting and working out an arrangement not to permit certain speech and the platforms working with the government to do the exact same thing. There's no difference.
Well, I think if the platforms entered into some agreement amongst themselves, that might raise issues under different provisions of law. The modest point I'm making is just that the government doesn't violate the First Amendment when it persuades a speaker to not distribute speech by someone else. That's Penthouse versus Meese, Judge Silberman's opinion there. That's what happens when the White House press secretary calls up the New York Times and says that was a bad op-ed. You shouldn't run op-eds like that anymore. I think that's commonplace.
Deneen Grant, good morning. You said who has the right to decide what is real information or misinformation? This is Orwellian. We saw that 4 years ago. We saw that during the Obama administration. We saw that during Occupy Wall Street, the early days of the social media age when people were talking about the war in Iraq and what it was really about. I saw your comment, Bunker TV, about Savvy Sabs. A shout out to her. I played a video last week. I don't know if I didn't see her show, but I'm sure she played it. That phone call that Jonathan Greenblatt did when he basically had a temper tantrum that everybody was putting out information about what the Israel-Hamas conflict is really about. And he didn't like it because it made them look bad. We know what it's about. Land, oil, water. Israel knows that the tide is going to start turning and they want to be a major player on the world stage. Again, everything is interconnected, even though you don't think it's connected. What do I mean? When you look at the current landscape of the last year, there's a certain country called Guyana that's about to make a major FU statement with the GT gold on the world stage in terms of petroleum. Regardless of who wins in November, trust and believe, I give it about 6 months after the inauguration. BRICS is going to throw their Thor-style Mjolnir hammer on the world stage, the global south, what they call it. In every country now, even though they don't like to report it, is applying for an application. That's right, I said it correctly. They're applying for an application to join BRICS. Israel, you mark my words, will be getting enticed to go to BRICS. You mark my words. But they know they have nothing to offer them right now. So they have to clear out Gaza because Gaza has arable land, which means food that can be exploited. I said it. They have petroleum deposits under Gaza, and they also have water that they've never tapped before under Gaza. And they needed that October 7th incident to have an excuse to clear those people out because those people had the right to that land. I said it. Now, I'm sure they'll take this video down because I said it. But if you take it down, that means I was telling the truth. This is why they want to make up these rules now and say that, you know, social media needs to be regulated. Notice they're only talking about TikTok. The rest of them are in bed with the government. Don't let Elon and his, well, I'm eccentric, taking ketamine, lying ass, talking about he's for free speech. He's a lying son of a bitch. He's all for censored speech unless you're white. You don't believe me? Go look at the live stream we did yesterday about his interview with Don Lemon. He admitted it. Then you can go on your social media, particularly X, and look at the white supremacists and look how they're saying Elon smoked him. They're in such delusions, they don't even realize what's happening. They don't like TikTok because TikTok is not American. Oops. Nah, I ain't got no love for TikTok. But if the truth is getting out anyway, you let it get out and let people figure it out.
Justice Alito?
On the traceability causation question, under Mount Healthy, if the plaintiffs show that the government's actions were a motivating factor, it is not their obligation. Isn't this true to show that they would not, that the platforms would not have done what they did were it not for what the government did? It would be the defendant's obligation to show that.
So I confess, Justice Alito, I'm not sure that the court has ever gotten through how that, whether that burden shifting inquiry applies in the context of traceability as opposed to an Mount Healthy merits type inquiry. I guess what I'd say is the court has been pretty emphatic that when your injury is attributable to independent choices by private actors, that's not traceable. And our submission is that that's what happened.
Well, wouldn't it be very strange to have a stricter standard on the merits, a less defendant-friendly standard on the merits than at the standing stage? It seems odd. I mean, one last question, really quickly. You've never argued that this case is moot.
We have not. No.
Thank you.
Justice Sotomayor?
Counsel, you don't do a lot with Clapper, and it seems that Clapper really does change all of the cases in terms of requiring a heightened traceability standard, does it not?
So I think Clapper is very instructive here. We do cite and rely on it. We think it's relevant to traceability. We think it's perhaps most relevant at the sort of the future injury question, because I think we're right about traceability of all of the past moderation of their content that they talk about. But I think we're on even stronger ground in saying that the vast majority of the things they're talking about are about COVID-19 or unusual idiosyncratic stories from the 2020 election. And their burden is to show that they face an imminent threat. That's from Lyons, that's from O'Shea, that the injury is going to recur. That's Clapper too. And what Clapper also says, and this is instructive, is that to the extent they're censoring themselves, which is what they say, in the absence of such an imminent threat of actual government-caused harm, that's not enough for our.
Can you go back to Ms. Hines' 90-day suspension? I'm not sure if this record is enormous, but do we know exactly what was censored for that 90 days?
So that's the problem. I don't think we do, or if we do.
I was looking for it and couldn't find it.
And when I would go through the red brief pages 19 to 21 and connect up the dots here, one of the things that's hard is that there's not a lot of specifics about even the dates on when things happen. I guess I will say when the dates are provided, though, they don't line up. The very first example on page 19 of the red brief is, I think it's Ms. Hines, she gets her retweet of Robert F. Kennedy Jr. suppressed by Twitter, and she says, that's an indication that my harms are traceable to the government because the government was talking about Robert F. Kennedy Jr. But she doesn't say the government's statements happened between January and July of 2021, and the moderation of her retweet happened in April of 2023. Years later, after Twitter had been sold, after it had abandoned the COVID-19 moderation policies that are at issue here, I think that's a strong indication that there's a real traceability problem, and it just gets worse when you look to the forward-looking injury that they have to establish.
Thank you.
And Justice Kagan?
On the coercion question, is there anything that we have to review on clear error, or is it all legal?
I give you the same answer I gave before. I think the historical fact that this statement was made, it was not made. If there were specific factual findings beyond that, again, of historical facts, we'd acknowledge they're clear error. But things like this was pressure, this was coercion, we think those are characterizations. And then the ultimate standard, the ultimate First Amendment standard of was viewed objectively and in context to this communicating a threat. We think that's either law or maybe more probably law to facts that gets de novo review the way it usually does in the constitutional realm.
And on the past harm, future harm question that you were just talking about, I take it if no future harm, that's independently sufficient, is that right?
Correct.
And would there be any difficulties with confining a holding to that if we were to find for you?
I don't think so at all. I think in some ways that's the narrowest, easiest way to resolve this case is to say this is an action for injunctive relief. They have to show that they faced an imminent threat of future harm. We don't have to adjudicate the parties' disputes about the past harm. We just have to show that they haven't met that burden.
Thank you.
Justice Gorsuch?
On that question, in your view, when is the time that we should be considering that? Probably not today, it seems, right? It would be the time that the court, in the first instance, issued the PI. Is that your view?
So I think it might be even earlier than that, just to be candid.
the complaint?
That might be the complaint. So the complaint for the states is, I think, May of 2022. The individuals get added in August of 2022. The place where I think I know for sure that the PI matters, though, is whether they've shown a likelihood of irreparable harm, which above and beyond standing is a requisite for injunctive relief. I think that has to be shown
at the PI
at the PI. Exactly.
Okay, so that's the relevant date.
Yeah.
Okay. And then when we're looking at coercion, is it in your mind a relevant consideration that the industry is very concentrated? And that therefore coordination problems that otherwise might be difficult with the media, which are very diverse, might not be present in some cases?
So Again, context matters, and I think in some ways the fact that these are very large, very powerful corporations cuts against a finding of coercion because they are very sophisticated. They didn't have any problem. They weren't shy about saying no to the government. I hesitate to say, though, that it suggests that you should change the First Amendment standards. I think the Knight brief is...
I'm not suggesting that. The Knight brief does discuss this and says it might be a relevant factor, that there's such concentration that it makes coordination between government entities and private entities easier. Do you disagree with that?
I'm not sure whether or not I agree with that, but I think the point is that for our purposes, the constitutional line is between coercion and not coercion.
No, I understand that.
And so the question
is of context-specific inquiries we've discussed. You pointed out one way in which concentration might make it less susceptible to coercion. Do we have to account for the possibility as well that in some circumstances, and I'm not, again, not case specific, it might may make coercion easier?
So if that were true, you would have to account for it. The reason I'm resisting is because I think the concerns about concentration in the industry go more to the potential effects of coercion if it happened than about whether or not coercion happened at all. I get that. I'm sensitive to that. And the point that I was trying to draw from the Knight brief was the First Amendment isn't the answer to problems of concentration.
No, I take that point. Thank you.
Justice Kavanaugh?
Just so I understand, your key legal argument is, I think, but correct me if I'm wrong, that coercion does not encompass significant encouragement or entanglement, and that it would be a mistake to so conclude because traditional everyday communications would suddenly be deemed problematic.
Exactly right. And really that what the lower courts have done here, I think, is to go beyond the coercion test and sort of to openly say, we're going to open up this state action encouragement door. And that, I think, risks turning the platforms and lots of other entities that are interacting with the government into state actors and restricting their editorial choices under the First Amendment.
By coercion, you mean threat of legal consequences or?
Adverse government action.
Adverse government action. Okay. Then on the killing people hypothetical, or not hypothetical, the statement, I mean, that raises kind of national security analogies. I don't know what your experience is if you've looked into this, but it's probably not uncommon for government officials to protest an upcoming story on surveillance or detention policy and say, you know, if you run that, it's going to harm the war effort and put Americans at, risk.
I can't profess to have had personal experience with that. I know it has happened. The Knight brief talks about some examples, and I think that's an example of a valuable sort of interchange as long as it stays on the persuasion side of the line. I think newspapers want to know if they're publishing a story might put lives at risk, and they don't have to listen to the government, but that's information that they can consider in exercising their editorial.
If they tack onto that, and if you publish the story, we're going to pursue antitrust action against you.
Huge problem. Yeah.
Right. Okay. And then you haven't really described what you think the common interactions are. I mean, what do you think those are?
At issue in the complaint or
no, just in general, you're speaking on behalf of the United States. Again, my experience is the United States in all its manifestations has regular communications with the media to talk about things they don't like or don't want to see or complaining about factual inaccuracies. But I'd be interested in what you want to describe about that.
Yeah, so I think that's absolutely right. And I won't profess to give you a comprehensive overview. We've looked at this very carefully in the context of these defendants because we've a couple times been under the shadow of this injunction. And so we wanted to understand exactly what would be at stake there. And so I think it comes into a couple of different buckets. One of them is engagement on matters of public policy. And I think that's what was going on here. I think childhood mental health, anti-Semitic speech, Islamophobic speech online are in that category. Those are issues where the White House, the Surgeon General, others might want to make their views known, to use the bully pulpit to call on the platforms to do more. Another is the national security space. I think the record is clearest there on the FBI providing these foreign malign influence selectors to the platforms for the platforms to take action if appropriate, or briefing them on foreign threats or about terrorist activity happening on the platforms. There's also a domestic law enforcement side of things, child exploitation, other things like that. The platforms are a vector for those sorts of activities, and the government communicates with them about that. There's also election integrity issues, false statements about the times, places, or manners of elections, saying the polls have closed early, don't bother coming to vote in an effort to suppress people's vote, or Democrats vote on Wednesday, Republicans vote on Tuesday. Those sorts of schemes are of concern to the law enforcement entities. And then I think there's also the CDC's interactions, which involve providing advice. By the way, we're seeing a lot of this information circulating on your platform. It's not true, or it's misleading about something that we've put out, or even just answering the platform's questions. I think one of the flavors you get from the amicus briefs on our side of the case is there are a lot of valuable ways where the government has information or expertise that it can offer to private speakers, and it would be a shame to chill that.
Thank you.
Justice Barrett?
So this might be a question about the distinction or the interplay between Bantam books and just state action more generally. In Justice Thomas's questioning of you towards the end, he was talking about the distinction between encouragement and coercion. So what if Facebook said, and this is counterfactual, it's not what happened in this case, but what if Facebook said, you know what, we're partners, we're on the same team, this is a once-in-a-lifetime pandemic, and we think it would be most efficient and most helpful for the public good for us to just turn over our content moderation to you. That's not coercion, that's voluntary on Facebook's part, but Wouldn't it be state action then?
So to me, it starts to veer over, and obviously with all the caveats, state action is incredibly context specific. I don't want to be definitive, but to me, that starts to verge more over into the joint action. We're doing something together. The government is doing things. It's actually making decisions. It's not just advising or persuading the platforms. I think the rubric, that may well be state action, but the rubric would be, I think, more sound in the joint action cases than under significant encouragement, which has never been just us trying to persuade you to do something.
How do we consider the relationship between those two things? Because I agree with you, Bantam Books is about coercion and drawing the line there, but clearly there are some times when things veer into the joint action space where we would say that maybe there is state action, and there's a dispute in this case. It kind of comes up in the next one too about which framework is the right one. What advice do you have?
Yeah, so again, I think if I were the court, I would want to be cautious about making too definitive pronouncements. I would say that here what's challenged is the persuasion, exhortation, bully pulpit, provision of advice, provision of information, and that when those things are at issue, the main yardstick is going to be Bantam Books. The main concern is going to be, have you crossed the line from just really trying to persuade to trying to threaten? And the Bantam is the right way to draw that line. I think there are a lot of different amicus briefs from a lot of different parties, like the Chamber and Net Choice. They all agree that's the right line in this context. I think you could reserve and say it'd be a very different question if you're talking about the government and the platforms acting together, turning over operational control, integrating their operations. That's
Why don't you just tell the truth, sir, that you have government officials on these boards? Why are you not telling the truth? It's already been done, sir. You have government officials going with Facebook and Twitter and what's the other one? Facebook and Meta, Alphabet, and X. They have credentials to get in that building and sit on those meetings. What are you talking about? You even have former ones sitting on there. Again, this Supreme Court doesn't want to be the one to legislate free speech. And as all the articles came out yesterday, one thing is evident. They don't want to mess up the access. Just like 4 days ago, they said, you know what? You guys can block people, but you have to meet a certain criteria for it to be lawful. And they can't come challenge it. But you know, that's them. That's them. So you call out a government official, you can block, and they don't like what you say, they can block you. Could be a constituent that's just asking a question. You get blocked. But, you know, every little step they try to take, they try to create a monster. Oh, Deneen, this country can't handle that. Because then, first off, that Congress they ain't got enough balls to do that. Number one, that's a 2/3 vote. They'll never do it. The Senate will never do it. But on the off chance that they ever did do it, y'all do understand that everything you say, somebody could come back on you, and they can't be prosecuted for what they do. I'm just saying. Or the more conventional thing is, then they can establish the rule on what you can and can't say. Might as well be Cuba without the cigars and the black beans. By the way, Cuba right now is protesting food shortages, since they don't want to tell you that either.
A different case, it might present hard state action issues, but it's just really not the kind of issue here.
And not alleged here.
Exactly right, yeah.
My other question is about the findings of fact and clear error. So you were pretty insistent with Justice Kagan that we really, to address this standing point, don't have to review any of the district court's factual findings for clear error. I just want to make sure that that's right, because I'm thinking about things you talked about with, I think it was Justice Alito, the interchange with the expletives, we're getting mad, we want answers now, are you whatever serious? And that was actually about his own Facebook account. Or there was another change that was exchanged that was actually about somebody impersonating the president's granddaughter on Twitter. So if the lower courts, which I think they did, kind of conflated some of those threats with threats that were designed to be threats related to the pandemic and that kind of suppression, wouldn't that then be clear error? Or do you think that's application of facts to law or what?
So I apologize. I didn't mean to say that there's no clear error here at all. I just meant to say it would be findings of historical fact. And I think the ones that
those count.
And those count. Those do get clear error review. But I think we pointed out places on the salient ones where they just are clearly erroneous. They're just demonstrably inaccurate in the two cases that you just identified. So there we might agree clear error applies, but to the extent that the lower courts were suggesting, and more the district court than the Fifth Circuit, but a little bit the Fifth Circuit too, that things were said to speakers that weren't said, that the press secretary said words she never said. Our argument there would just be that those are clear error.
So in considering traceability, you would say that maybe there are some things that we would review for clear error because the erroneous, assuming that you're right, the erroneous conclusions about traceability depended partly on factual errors and then partly on applications of law to fact.
And an incorrect legal standard, yeah.
Thanks.
Justice Jackson?
So I guess I didn't perceive there to be such a sharp distinction between Blum and Bantam books. The government seems to be arguing here that Bantam books is the way to go, that Blum is not the right test. And I appreciate that Blum uses significant encouragement, but I think it says the question is whether the government, quote, has provided such significant encouragement, either overt or covert, that the choice must in law be deemed that of the state. That it's sort of suggesting in the same way that Bantam books is that it's really about coercion as opposed to just encouragement. So am I wrong to think there's really not that much difference between the two?
So I don't think you're wrong there. I think we say that that's the way you ought to read the significant encouragement language, that it's positive incentives of government action that overwhelm the private party's choice and make it really the government's choice, not the private parties. You can just view that as the flip side of the sort of coercive threats from Bantam books. I think the reason why you may have sensed me today and us in our briefs resisting Blum is because the lower courts and my friends on the other side have really tried to turn that significant encouragement language into something quite different, into circumstances where the government encourages in some colloquial sense by urging or persuading or really strongly advocating something. And we just don't think that's what Blum means or what this court state action cases have ever said.
Okay, I understand that. And even if we have a world in which significant encouragement is verboten, is there something different to the government providing information?
Yes.
I'm a little worried about the respondents, what I think could be taken away from their view, which is that in situations in which the government has information that may be unique to the government's knowledge, but that it feels important for the public to have, that somehow becomes prohibited if, as a result of that information, these companies decide they're going to do something different with respect to content moderation.
That's our big concern too, and that's exactly what the lower courts found crossed the line. The FBI providing information about covert foreign actors on platforms, the CDC providing information or even answering questions about matters of public health. I think it'd be very troubling to say that those things are impermissible or create state action.
Thank you.
Thank you, counsel. Mr. Aguilaga?
Good morning, Mr.
Interesting. So she's sitting there arguing that the government should be allowed to say things on a matter of public health. But again, we ask the question, what's the truth and what's false? This is why social media, especially on TikTok, blew up in the last couple of years, because people were doing their own research and putting out the information they found that the government won't say. Trust and believe, family. And I know this might sound off code, but most people would have had a more informed decision about the Belle Biv DeVoe if they would have let everything ride. We wouldn't be here right now. But, they wanted their agenda pushed, so. Well, Deneen, yes, they are doing all the lying, but here's the thing why they still have supporters. They sprinkle a little bit of truth into it. As long as there's a little truth, it's okay, because it's not a complete lie. Yes, they did. And they were banned, and then they became the disinformation dozen. And they became pariahs. Houston lets their doctors go that went online to tell the truth or refuse to give the Belle Biv DeVoe. We know that. I think that case is still pending, actually. But the government also said that the manufacturers cannot be sued directly. So now people are figuring out the end arounds. It's going to be an interesting few years. It's going to be an interesting few years when things start really getting realigned. So we're going to go down. Where is it? Okay, so this is the Louisiana Solicitor General. Now, he and the one in Missouri brought out this lawsuit as well. So let's hear what he said.
Action issue, just like you addressed it in Bantam books. You use that term 4 times in Bantam books.
And could I just understand, because it seems like an extremely expansive argument, I must say, encouraging people basically to suppress their own speech. So, like Justice Kavanaugh, I've had some experience encouraging press to suppress their own speech. You just wrote a bad editorial. Here are the 5 reasons you shouldn't write another one. You just wrote a story that's filled with factual errors. Here are the 10 reasons why you shouldn't do that again. I mean, this happens literally thousands of times a day in the federal government.
Yeah, and I would say in the Mine Run case that you're describing to me, it's the government going after the speaker itself and trying to get them to change their speech. What's so pernicious here is that you don't see any of these facts in this record unless we get discovery, which is when Rob Flaherty, who's deputy assistant to the president, sends an email to Facebook or to Twitter and complains that they're not doing enough to censor what they view as vaccine hesitancy speech. America never sees that. And the third party, people like Jill Hines and Jim Hoft, whose speech wishes to express the kinds of viewpoints that the White House is targeting, they never know that that's happening behind the scenes. And I think it makes a difference, Justice Kagan, that you have an intermediary here who really has no incentive to itself defend Jim Hoft's speech or to defend Jill Hines' speech. In the New York Times hypothetical, you have a storied publication that itself is familiar with those kinds of
op-eds? What about op-eds?
Your Honor, and with op-eds, if it's a third-party speech that
that happens too, right?
And I guess there are a number of ways I would think about that, Your Honor. One is if the newspaper declines to run an op-ed because the government asked, that op-ed author can go to any number of other publications and it has an outlet. It's not the same here, because if I'm on Twitter and I wish to express a viewpoint that the government wishes to censor and Twitter bows to that pressure, then I lose my account.
I was just going to say, first, I have no experience coercing anybody. But second, I mean, the government is not monolithic either. I suspect when there's pressure put on one of the platforms or certainly one of the other media outlets, they have people they go to, probably in the government, to say, hey, they're trying to get me to do this, and that person may disagree with what the government's trying to do this. It's not monolithic, and that has to dilute the concept of coercion significantly, doesn't it?
Your Honor, I'm not sure I agree with that. And I guess I'd get back to one of the earlier points I made, which is, whether you call this coercion, if that's the label you attach, you call it encouragement, you call it promotion, you call it inducement, whatever it is, if the government is attempting to abridge the speech rights of a third party, that has to be unconstitutional because that falls within the plain text of the First Amendment. And so, this is Bantam books of the 21st century. You haven't had a case with social media platforms like this where third party speech is so at risk of being censored.
Well, but how do you analyze a situation where maybe EPA is trying to coerce the platform about something and the Army Corps of Engineers is trying to coerce them the other way? I mean, you can't just sort of pick and choose which part of the government you're concerned about.
Your Honor,
and obviously it's a different when you're talking about what the president is saying in particular, but other than that, I think.
So when y'all going after the NSA one time, let me know. When y'all going after the telecom industry one time? Or maybe we missed it. Maybe we missed it. Y'all let social media get in bed with the NSA for years. And now you want to do something. Y'all had your boy. You had your boy Obama spying on the AP, and y'all were cool with that until it got exposed. Then y'all wanted to fight for the rights of journalists. This is a game. All right.
It's a very more fluid situation than anything else.
It is fluid, Your Honor, but I would say that when you have, as we have plaintiffs in this case who wish to express certain viewpoints that have been specifically targeted by the government, it's not at least fluid in these facts. And this is not a case just about COVID. It's a case about election integrity. It's a case the district court has a finding about how the
So,
government.
what about that? Take an example where, these platforms, they're compilers of speech, and some part of the government, let's call it part of the law enforcement arm of the government, says you might not realize it, but you are hosting a lot of terrorist speech, which is going to increase the chances that there's going to be some terrible harm that's going to take place. And we want to give you this information. We want to try to persuade you to take it down. The government can't do that?
The government can absolutely do that, Justice Kagan.
They're asking them to take down the speech.
Terrorist activity, criminal activity that is not protected speech. Absolutely, the government can inform the.
Well, that much it might be protected speech. If terrorists engage in, let's say they're just recruiting people for their organizations.
Your Honor, if it's First Amendment speech, protected speech, then I think we're in an entirely different world. That's the case where, and this comes up in the FBI findings that the district court made, because what was happening is the FBI was sending teleporter encrypted messages to the platforms identifying what the government represents was foreign actors. The district court found the government was not distinguishing between whether it was domestic or foreign conduct. And the way this issue arises is when maybe you have a foreign actor who tweets, I love Biden, and there are 20 million people who wish to retweet that, repost that with their own comment saying, heck yeah, I love Biden too. When an American does that, that's First Amendment protected speech, Your Honor. And so when the government comes in and tries to take down every single post that contains the core that they say was foreign speech, but they're also taking down the added speech by Americans, that's a square First Amendment issue, Your Honor.
So back in this still happens now. Decades ago, it happened all the time, which is somebody from the White House got in touch with somebody from the Washington Post and said, this will just harm national security. And the Washington Post said, okay, whatever you say. That was all. That we didn't know enough, but that was coercion.
Your Honor, I thought I understood the government this morning to say that might be a First Amendment issue. And I think what I would say is if there's a national security interest, maybe the government can satisfy strict scrutiny in that circumstance. What I would also say is we probably wouldn't have a lawsuit based on that, because I don't know how that we would get prospective injunctive relief based on a fleeting offhand, reach out from the White House.
I guess what I'm just trying to suggest is that there's all kinds of things that can appear on these platforms that do all kinds of different harms. And the inability of government that you're suggesting to reach out to these platforms and say, we want to give you information that you might not know about on this, and we want to give you our perspective on what harms that this is doing. And we want to be able to answer questions that you have, because we really do think that it would be a good thing if you, on your own, chose to take this speech down.
And Your Honor, if those were the facts in this case, then I think it'd be a much harder case for me.
I don't know what your standard is. You just told me that was good enough for you. That was coercion.
No, Your Honor, because in that circumstance, you have a platform who's reaching out, or the government reaching out, just to identify what it views as the right state of the law, right state of facts. The government, this court has made clear for a while, since its plurality opinion in Alvarez, that if the government thinks there's false speech out there, the remedy for that is true speech. Nothing prohibits the government from going to that platform and saying, we've seen a lot of false information about election activity and COVID and vaccines and the like. Nothing prohibits the government from saying, here's a list of everything we say is true, that is true in our view, and you should amplify our speech. And anytime that false speech arises, you should put our post right there next to it saying, this is the government's view on this issue. The problem here, and this is, I think you see this in the summer of 2021, after the White House goes nuclear on the platforms, is that the platforms themselves reverse course on their own policies. And you see this in ROA 15322. This is one of the in my view, one of the hottest docs in the JA, because you've got this email from Nick Clegg, who is, former Deputy Prime Minister of the UK. And after all of this pressure for months and months and months, he sends this email to Vivek Murthy, the Surgeon General, and he says, Dear Vivek, thanks for taking the time to meet. I wanted to make sure you saw the steps we took this past week to adjust policies on what we're removing, to take steps to further address the disinfo dozen. We've removed 39 profiles, pages, groups, Instagram accounts. We're continuing to make other accounts harder to find. This is an example of platforms moving beyond what their own policies require because they felt pressure to take more action and to censor more speech. And Your Honor, if that's not the clearest example of the government,
tell me where you have in the record that the 39 accounts that were taken out, that any of them related to any of the petitioners here?
Sure, Your Honor. So what I was
give me that site again.
What I was quoting to you right now is ROA 15322, and what that email from Nick Clegg mentions is the so-called disinformation dozen. This is a group of people that the government thought was responsible for the majority of so-called health misinformation on social media. Now, in paragraphs 5 and 6 of each of the supplemental declarations in the joint appendix, each of our individual plaintiffs specifically identifies the fact that they follow members of the so-called disinformation dozen. They repost their posts, they engage with their speech. And so when the government or when the platforms here in response to the pressure are taking down contact and accounts related to those individuals called the disinformation dozen, that is necessarily impacting our plaintiffs' right to engage with their speech, to add their own
Not
comments.
that they've taken down any of their posts, but that they took down someone else's posts. That's what this is saying.
That's what I was quoting to you right now,
I'm
Your
not
Honor.
sure how that shows traceability or redressability.
In the same vein,
And I don't think we've ever dispensed standing on the basis of injury to another. Injury to you, but not to another.
So, Justice Sotomayor, let me give you Jill Hines one more time. Look at JA 793 to 794. This is the tweet that, or it was a screenshot of a tweet that Mr. Fletcher mentioned. And this is censorship 4 times over, because this is a tweet in April 2023. It's on the eve of the preliminary injunction hearing. And what she says is this Facebook post that I posted was taken down by Facebook. She got a warning for it as a violation of the community standards. What was that post? It was a screenshot of Robert F. Kennedy Jr., who was a member of the so-called disinformation dozen. What was the RFK tweet talking about? It was talking about Tucker Carlson, whom the administration was obsessed with. Look at JA 701 to 708.
I'm sorry, the RFK tweet, there's only a record of the White House asking Twitter to remove a tweet on, and not particularly this one from RFK. That doesn't help Hines's claim that the White House asked Facebook to remove anything.
It does, Your Honor, because, and this is a good example of the interrelationship between the various media platforms. You have cross-posting. So what happened in this example is Jill Hines took a screenshot of a tweet, and then she moved that over to Facebook and posted that as her own Facebook post. And so when she did that, she moved RFK's tweet, and I was going to describe what was in that tweet. He was talking about Tucker Carlson, that the White House specifically targeted in the joint appendix. And
I have such a problem with your brief, Counselor. You omit information that changes the context of some of your claims. You attribute things to people who it didn't happen to, at least in one of the defendants. It was her brother that something happened to, not her. I don't know what to make of all this, because you have I'm not sure how we get to prove direct injury in any way.
So, Justice Sotomayor, let me start by apologizing if any aspect of our brief was not as forthcoming as it should have been. I would take full responsibility for that. I apologize for that, Justice Sotomayor. What I would add to the second part of your question is I think Jill Hines is the best standing for our case in multiple ways. I think one of the ways you look at her standing is you look at JA 715 to 716. This is an email to Facebook where the government, the White House, specifically asks Facebook to not distribute so-called vaccine hesitancy content and also to target health groups that do that. So that's JA 715 to 716. Then you go down earlier in the JA to JA 631 to 632. This is Jill Hines' allegations. And what she says is 2 months later, so the email I just described to you from the White House was in May, 2 months later in July, and then a couple of months later in September, Jill Hines had 2 health groups in Louisiana that were blocked by Facebook. And I think this is one of the scariest examples in the record of what is at stake here, which is those groups were political action groups. Louisiana had a legislative session in progress. And what Jill Hines was trying to do is mobilize people to support certain bills and other legislative materials that were then pending in the state legislature. But because the government moved its pressure and put them on the scales, a couple of months before, and then lo and behold, once Jill Hines tries to use the exact kinds of groups that the government targeted, she can't. They're pulled down. Her political organization is stymied, and that's all over the record. And that's just one fraction of the kinds of harm that's at stake here.
So can I ask you?
No, go ahead.
I want to go back to actually your interchange with Justice Kagan about the standards, because I have to confess it left me very confused. It sounded like you were articulating different standards depending on a different legal standard, depending on different factual circumstances. For example, when Justice Kagan gave you the hypothetical of pressure being placed on the New York Times or the Washington Post not to run a particular op-ed, it seemed like you backed off and said, well, significant encouragement wouldn't be enough there because the person who wrote the op-ed can go to another news outlet. You also made the point that this is just different because social media is such a concentrated industry, which is a point that Justice Gorsuch was asking Mr. Fletcher about. So can you clarify, did I misunderstand? Because it seems to me that as a matter of law, the same legal standard would have to apply across all of these areas.
I think that's right, Your Honor, and I apologize if I wasn't clear earlier. I guess the top line legal standard I would start with was this court's line at 635 in Norwood, which is the court can't do indirectly what it's constitutionally prohibited from doing directly. The second line in response to that is, well, what sorts of indirect mechanisms can the government use that would run afoul of that rule? I think one potential mechanism is coercion, another one's encouragement. This court also has used the term
Just plain vanilla encouragement, or does it have to be some kind of like significant encouragement? Because encouragement would sweep in an awful lot.
I think that's right, Your Honor. And so let me give you two answers to that. The top line answer is, I mean, I'm a First Amendment purist, and so I would say even mild encouragement, but we don't need that to win in this case because we are so far afield from whatever that threshold is. So if you want to say substantial encouragement, like the Fifth Circuit said, and like Blum said, absolutely, that's a standard that works. But I guess what I don't.
Well, let me just ask you then. Let me give you a hypothetical. Let's say that you get doxxed, and so do numerous other members in Louisiana state government. You're doxxed, and somebody's posting online about how people should really rally and do something about this. People should rally, and you should be harmed. Okay, the FBI.
Okay, ma'am. Y'all's Maxine Waters did that years ago. Y'all didn't say nothing. Y'all watched her go on social media like a fool, saying disturb sitting Congress people who are aligned with Trump. How is that not doxing? She actively encouraged people to go research people, which you should do, but you know how people hear the word disturb and other key phrases. You know how people are going to interpret that. But y'all were cool with that. Now when it becomes social media where y'all can't catch a person straight there in real time, now it's a problem. That's not how this works. This is why people don't trust the government, because they don't keep the standard the same for everybody, or at least similar. You're really sitting here trying to argue that what the D12 did, that shouldn't be cool, but you're cool with the CDC lying or not giving out all the information so people can make their informed decision. They're basically arguing that y'all let the CDC and the government scare people into getting something that they should have been able to research first and then make an informed decision. And this goes back to how people were losing their jobs. People were losing their licenses to work. They were losing their livelihoods. They're arguing that falls under free speech. Now, I don't know how far they're going to get with that, but that's going to be a lot of lawsuits if they rule that social media should be complicit in some capacity of what goes on their platform. But again, they'd have to knock down 230 to get the full flavor of that. I don't think they're going to do that because that's going to be billions they're not going to get. But, all it comes back down to money. Fuck them.
FBI sees these posts and calls the social media outlet like X, Facebook, whatever, and says, we really encourage you to take these down.
You did that to the New York Post. Oops. You see how they're dancing around, bringing up the laptop? You see this?
And folk, them white people lost their mind.
And a lot of white folk have demonstrated eloquently that they don't have no sense.
I really wish these two, the Solicitor General and the solicitor from Louisiana, would have just brought up the laptop, because the entire world saw a blatant example of the government overreaching. Blatant. You had somebody running for a government seat use their power and influence to get a story suppressed. Why are y'all scared to bring that up? That happened on social media. It's not like the New York Post. They were only regulated to print media. They would have to go to every newsstand, every news kiosk, every home with a subscription to take that down. You easily could have disseminated that through social media and you had them take it down. And you watched how that decision and how that played out affected 4 years. You've seen it, but y'all want to play it. Y'all want to dance around it. So let's get the dancing. Let's get the dancing. Whew. This is fuck it. If they rule the way I think they are, and I've seen scarier things. If they rule the way I think they will, and this happens.
Continue with the moment of truth in just a moment, but first, a word from the official sponsor of Black Empowerment, Power Tools. There's no telling when something's going to come up, so make sure you carry your power tools at all times. You never know when you're going to need to bring the hammer down, or when you'll have some trash that needs to be blown away, or some obstacle that requires cutting down. Don't get caught empty-handed. Keep your hammer close by. Keep that leaf blower at the ready, and always carry your steel. Power Tools, because no matter what your day job or side hustle may be, there's no excuse for not being ready to put in some work.
Make sure y'all got that. I'm telling you, they're going to rule that even though they were right, there's nothing they can do about it because we got to protect free speech. They're going to give some leeway, but they're not going to say social media got to be, these publishers have to be wholly responsible for what's put on their platforms. They're never going to do that. Oh, by the way, Jude Knight, good morning. I saw your comment. You said one would believe they are playing chess by the way they speak. Truth is they're just playing checkers. Nasa. They're not playing that. They're playing a game that is old as black time.
You know, let me go here. There's I'm gonna move on. There's a growing concern in
That's what happens when they found out they get the people don't like what they say and they go against the perceived narratives and the narratives that we should follow. Yeah. Don't let old boy tell you that, hey, they starting to rise up. Think about it. Why you think all of a sudden now Biden will go outside in a crowd? He got Secret Service. He should go out in the crowd. He doing home visits with fried chicken and taking selfies and videos with rappers because those are the safe Negroes. He know damn well he can't step foot in Chicago. If he goes to Chicago right now, he gonna have to get back on the plane. He come down here to Atlanta, he gonna have to get back on the plane. LA, New York, especially New York. We don't like Pennsylvania, even though people move there. But yeah, he can't step one toe past DC or that mid-Atlantic area. Can't do it. People gonna be out there waiting on him. That's why he sends Command Me. Come on, Biden. Hey, come. Try that Charlemagne crap with me.
You bring him here. Right here. Do you hear me? Right here. What? You heard what I said. Just do it.
Bring him here. We'll get him right. We'll I'm telling you, I'll get him to be the racist that he is. Cause he tried that if you don't vote for me or Trump, you ain't black. I'm gonna say great. And if you vote for a white supremacist, you like yourself, you deserve everything you get. And if you vote for this man, he'll die in the Oval Office. I will say that to his face. and then I'll lose my channel. But anyway, that's pretty much what was happening down there yesterday. Free speech is on the line. So let's hear what old Katanji had last to say, and then I'm getting up out of here.
Encourage, perhaps even coerce, because they have a compelling interest in doing so. And so that's why I keep coming back to the actual underlying First Amendment issue, which we can isolate in this case and just talk about coercion. But I think that you have to admit that there are certain circumstances in which the government can provide information, encourage the platforms to take it down, tell them to take it down. I mean, what about the hypo of someone posting classified information? They say it's my free speech right. I believe that I got access to this information and I want to post it. Are you suggesting that the government couldn't say to the platforms, we need to take that down?
No, Your Honor, because I think that would be a great example where strict scrutiny would cut in the government's favor.
All right. So what do we do then in a situation in which, I mean, I suppose in this case we're asking, the government's point is we didn't coerce, and I appreciate the debate about that, but you just seem to suggest that as a blanket matter, the government doesn't have the ability to encourage or require this kind of censorship, and I don't know that that's the case.
So, Your Honor, I guess this goes to the bully pulpit as well. As I understand, the bully pulpit has never been used to target the object of suppressing a third-party speech. You can use it to coerce behavior, you can use it to coerce companies to take certain actions, but when the government is identifying a specific viewpoint and specific content that it wishes to wholly eliminate from public discourse, that's, I think, when the First Amendment problem arises. And so I guess I'm struggling to find an example in the court's cases or in history where the court or anybody else has said the government, by virtue of being the government, can use its power to pressure speech intermediaries to eliminate entire viewpoints and content from the public discourse. And I think, I mean, that's Your Honor.
Can I give you a hypothetical?
Sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. This is obviously extremely terrible, and the public shouldn't tolerate this. Platforms, we see what's going on the platforms.
But they can't call the platforms and say, listen, we really think you should be taking this down because look at the problems that it's causing.
If it's protected speech, Your Honor, then I think we get closer. But look, if you think if that's clearly the way you're asking the question, I understand that the instinct that may not be a First Amendment issue. I guess what I fall back on, Your Honor, is that at least where the government itself, there is no emergency like this. There's nothing.
No, my hypothetical is there is an emergency. My hypothetical is that there is an emergency. And I guess I'm asking you, in that circumstance, can the government call the platforms and say, this information that you are putting up on your platform is creating a serious public health emergency. We are encouraging you to take it down.
I was with you right until that last comment, Your Honor. I think they absolutely can call and say, this is a problem. It's going rampant on your platform.
Deneen Grant, you asked a very important question. Why do we need hypotheticals? Because this is the way they could justify their bullshit. You make up a scenario so you can rule on it and hope to God that you can figure out all the angles before it becomes a reality. So when it does become a reality, you already have the answer already set up the way you need it to be set up. It's the same thing they do with these doomsday scenarios, or if you live in a big city when they do their terrorist preparedness tests, like they'll do something in the subway, they'll simulate a terrorist attack. They're trying to figure out all the angles. The government's no different. This is what they do. They run these wartime scenarios all the time, trying to figure out what's the best response and the best way they can make money off of it. This whole social media thing is no different. That's why they're over here having these arguments, trying to figure out, okay, how is social media going to look if we uphold what we've been doing, which we already know it's just going to get worse because the white supremacists are desperate. But if we do some limits on free speech, it may be even worse, but we'll still be able to make money on it. Or if we just abolish it altogether, this may not be a country anymore. They know we are the linchpin that keeps this country together. Shout out to the linchpins. Put a pin emoji in the chat. as much as they hate us, if we just decided to say, you know what, let's take a day off from social media, which I've said this before. I think May 25th, we should all take a break from social media because unfortunately that was the day George Floyd was mercilessly killed. And we already know the white supremacists going to have their memes ready, because they slow. It's taking them 2 months to create a meme. So I say, as Black people, we just take that whole day off. Like, if you want to be in contact with your people, use DMs. Use the YouTube channel. See how people are doing that day. Converse with each other. Get phone numbers. Let's go back old school. Let's get the phone numbers. And we just talk to everybody. Let's leave social media that day. I swear to God to you, they will come out with a report that Monday and say May 25th was the worst day for social media because of the amount of money they lost because Black people didn't say a word on there. And all they're going to be able to highlight is the white supremacists and their white adjacent crowds just making fun of Black people. They will be exposed to the world. Yes, it does, Lewis. And good morning. Yes, it does. This is all about free speech, which I told y'all last week. The TikTok issue is about free speech and about the Star of David. That's all this is about. So I'm calling on all Black folks, intelligent Black society, even you coons that actually are redeemable. May 25th, 2024, we all take a day off. It'll be a graduation of sorts. We still remember George Floyd and what happened to him, but we should no longer engage with them white supremacists when they put up a George Floyd post. Let them have their little laughters by themselves. I'm also suggesting you don't even put up an Ashley Babbitt meme. Don't even do it. I say don't use social media for that whole day. Don't even do it. We gonna learn them. Just like they ran and said that reparations is no way that the government's ever going to talk about reparations. And what are they doing? Talking about it. We don't say anything. We don't react to them George Floyd stuff. That joke's gonna get old real quick. So pass that along to your people. But I think we got the gist of this, family. Well, Deneen, that stuff is coming out now. They're not going to be able to ignore it anymore, especially with the young kids. Can't ignore it anymore. And what really hurt them is it wasn't us that came outside on it. Because if we'd come outside and that was happening too, they could have ignored it. Their women came outside on it. All the major congressional testimonies were from the affirmative action crowd, aka white women, especially the woman who lost 3 of her 5 kids. Yeah. But anyway, y'all, I'm finna get up out of here and get ready to go plantation. I'm glad y'all stuck with me here on a not announced live stream. Hopefully you learned something. If you did, I done my job. If not, I will try to be better next time. Now, next time you will see me is tomorrow. Unfortunately, we will talk about that Mahogany Jackson case. I really didn't want to touch it because it's just, I don't know how the hell I'm going to report that. I don't know. The contents are disturbing. I don't know how I'm gonna get through that. But yeah, we're gonna try. And please also join me Friday, 10 o'clock in the morning for the members. Y'all are getting a members only live stream. It will not be broadcast on X because I know as soon as y'all see the images that I have on X, they're going to suspend my account. That's going to be members only. And it's going to stay members only because that cannot go into the lengthy lexicon of YouTube. Y'all going to like the subject matter, and then y'all going to cuss me in the comment section once you see it. So if you are a member, you'll get access. And I'm going to have to change the thumbnail also. The thumbnail that y'all are going to see in the live stream is not going to be the thumbnail that they see when they pass by my channel and see members only, because I can't do it. Because the thumbnail I have in mind is wild. But that's going on. So if you're not a member, remember it's 99 cents. It helps me reinvest in the platform, give you those type of live streams, and buy toys for the baby. So there's that. All right, I'm out of here. Take care. Stay safe. Vote the Couch 2024. And you know what to do when the agents of chaos come to mess up your existence.